the success prong, right?
Well, each one of the elements there's a problem. And let's start with irreparable injury. There was no evidence in the record of irreparable injury as to any of these plaintiffs for whom an injunction was granted, and it is limited to the Hernando County children. None. There's no evidence in the record at all that those children would be harmed through retention. None. That's problem number one. The Eric V. versus Causby case, which we cited in our briefs, it's an Eastern District of North Carolina case, very similar to this situation, a required test in order to be promoted. And the court in that case, with due process and substantive due process and equal protection claims, found there is no irreparable harm for a student to not be promoted. And so that's the first issue. The other thing is there's an adequate remedy at law. As we've pointed out, they could have gone, if they were really challenging the rule here, the state board rule, they had an opportunity to challenge that administratively with DOA. And they didn't do that. And the judge acknowledged that, but then she went off into a different direction in a way that no one asked for. But that's still a problem. The other adequate remedy at law is all of these children were given an alternative to be promoted under the statute. All of them. And that's undisputed.
Although Hernando County was denying the polio option, were they not?
What Hernando County said was that before we will offer the portfolio option, we want you to either take the FSA, which is the Florida Standards Assessment, or an alternative assessment, which is one of the other good cause exemptions. In that county, it's the SAT 10.
Did the department specifically speak to that?
The department, sorry.
It was offered in other places, well, Orange County, for instance. Did the department ever tell Hernando County either you can or cannot do that, your interpretation?
The department's position on that was that the local school board could make the decision that before they would go to the portfolio option, that the students should either have an FSA score or an alternative assessment score. And the reason for that is, again, from a local control standpoint.
What if the Hernando County had taken the opposite view? That we're just going to go straight to the folio option?
That was within their prerogative to do that too under Article 9, Section 4.
Yeah, that's what I'm trying to understand. I mean, it seems to me that, and it's going to go back to what Mr. Bush is going to be arguing, but aren't we just talking about an issue that should have been taken up with each of the local school boards?
Yes, yes. And again, these plaintiffs aren't entitled to their preferred exemption. They are entitled to an exemption if it meets the requirements. And they were all offered an exemption to be promoted to fourth grade and refused it. So there's no adequate, there's an absence of showing. There is an adequate remedy at law here that was available. And the court actually acknowledged this in her order, said if to the extent that the children were given an alternative good cause exemption, temporary injunctive relief would be improper. She was right about that, but then went on and granted it. It makes no sense. And the other issue that on the elements, on the merits, this is rational basis. There's no fundamental right at issue. There's no suspect classification at issue. It is obvious that the state has a great interest in this policy, which has been successful. The state also has an interest, and the school boards have an interest in local control of their schools.
And so what is the state policy? Does it get back to you have to actually participate in the tests to have the trigger of all these other alternatives to have these other alternatives being triggered? Is that the policy that the state has that she is subverting with this order? Or I'm still struggling to.
What's being subverted is the statutory requirement in 1008.22 and 1008.25 that these children must take the test. Must. It's mandatory. They shall participate, and it's mandatory. So they've subverted that. And with respect to what the state has done, they have given school districts the authority to do what Hernando has done, which is to say, we want you to take the FSA, which is required by law, or we'll offer you the SAT 10, which is an alternative assessment, and then we'll look at that, and then we'll decide what is your deficiency, what do you need to be remediated, and then we'll get into a portfolio. And other districts can go straight to the portfolio if they choose.
What is the Department of Education's authority? I mean, what, if any, authority do they have over the school districts? I know they have none over the promotion decision, but what can the department tell? What guidance can it give? Is it binding guidance? If the state were to say you must go through an alternative assessment first and then the portfolio option, would the districts be bound by that?
There is a shared responsibility under the Constitution, and there is a tension between what the state board can dictate and what the state board can't dictate. And in this instance, 1008-25.2 says that local school boards have the authority over student progression plans. So promotion decisions are made locally, and that's under law. And that emanates from Article 9, Section 4. And so in this instance, promotion decisions, the ultimate decision, again, all this is discretionary.
What if the school board just said, okay, we're promoting all these kids. We don't care if they didn't meet the test? I mean, wouldn't it
Well, they would have to comply with the portfolio requirements and the elements of what is required in statute.
You have some, by saying they have to do this, the state does in fact have some authority over the promotion decision.
Well, under law, yes, and legislatively, and that's what we're talking about. And of course, but what that law also talks about is that they have great discretion to make these decisions, which is appropriate, really, when you think about it.
Could the State Board of Education adopted a rule that says, to implement this statute, that participation means making a good faith effort to answer the questions correctly? Do they have the authority to adopt such a rule?
I believe the State Board would have authority to do that. However, this is also not that complicated. Participation means participation, and when you look at the rest of the statute...
Well, I guess where I'm trying to understand is what, if you did adopt that rule, a school district then couldn't say, well, we consider participation to mean showing up and writing your name on it. That would be some level of authority you have over the process.
Theoretically, that could happen. Here, of course, we're so far from what happened here. I mean, it's very clear. Everyone agrees. They told their children, don't take it.
Well, again, I think, as I understand, maybe overly simplifying what the trial court did, I mean, she basically told the Department of Education to do that, to adopt a rule. She didn't say it in those terms, but to provide guidance. The only way an agency can provide guidance is through a rule. Adopt a rule that says you can opt out of the test.
Yeah. And, of course, you know, other than this small group of people, there's no uncertainty about what's required when it says to participate and it's mandatory. I mean, no one has thought about this until this came up. And this has obviously been a subversion, and there's no equity here. They're not entitled to equity. None of the elements have been established. And it's based on a completely erroneous understanding of the law. I see I've got 11 moments, and I've already taken Mr. Bush's time. So I know he's anxious to get up.
Counsel, it is the state's position that athletes fail to show or establish any of the four prerequisites granting a temporary injunction.
That is correct. They failed to establish that in the record of the hearings, and Judge Gievers failed to cite to any evidential support for all of the four elements. In addition to the fact that,
must they establish all four as a prerequisite for granting a temporary injunction?
Yeah. If they don't do, if they miss one of the elements, they lose, and they missed all four. And the judge did not find factual findings as to all four. And so they lose on that basis, as well as on the misinterpretation of the statutory obligations and the failure to exhaust administrative remedies. And I apologize to Mr. Bush.
Okay, stop the clock for a second. I'm going to exercise an equitable remedy. Mr. Bush, we're going to give you an additional 5 minutes. So you're going to have 10 minutes to argue, and you will have an additional 5 minutes on the appellate side.
Thank you, Your Honor. May it please the Court, I'm Richard Bush. I represent Hernando County, and I want to just underline what was just said. The court below did not meet any of the four requirements of an injunction, and what we were ordered to do, which flies completely into in the face of the scheme that the state has set up to preserve these students. What was not said, because I guess there wasn't enough time, is that Florida was in the lower 10 states of the United States in terms of reading proficiency for children who were going into fourth grade. And what we all know as people who work with children is that you learn to read from first grade to third grade, and then you read to learn from fourth grade on. If you don't know how to read by the time you get to fourth grade, you can't learn. And that's the key to the door to success for these kids. So,
okay.
But the venue, I'm sorry.
Bush, I'm going to cut you off.
Sure.
Because I think as far as these standardized tests, you might get 3 different views up here of whether they're good or not, but that has nothing to do with the legal issues in front of us, except arguably the likelihood of success. What I'm concerned is that the Hernando County position concerning orders that they receive from the state, the home venue privilege, and whether, if they had sued you in Hernando County, would you have moved to get the state in as an indispensable party?
I'm sorry, I didn't hear the last phrase.
The last part would be if you had been sued in Hernando County and they just sued your client, would you have moved for the state to be joined as an indispensable party?
No, Judge, because they're not an indispensable party, and neither is that a new fifth exception to the home rule venue privilege. The state's not an indispensable party here. What the state, the challenge to the state would be the statute's wrong or it's defective, and the rule is wrong or it's defective. We raised exhaustion of administrative remedy there in our brief in challenging venue as well, because we felt that they failed to exhaust administrative remedy. No, we can be sued by ourselves, standing alone in Hernando County, as can each school board, because it's about what we did with our students in our county. That's exactly what happened, and each of us should be tested in that. Each of our conduct should be tested in our counties based on what we did. That, I believe, is the answer to your question. We were enjoined, again, in the face of the whole scheme, we were enjoined and told either accept a portfolio or a report card, and that is enough for promotion. Well, a report card is not enough for promotion. The only evidence, and again, this goes to Judge Lewis's question, all four of the elements are not dealt with here. The court does not find any evidence on all four, but the only evidence was from our testing administrator, that the report cards are not a good indication of whether you have reading proficiency, and by Mary Jane Tappan for the state of Florida, who said all of the data says it's not. So from a home venue perspective,
as I understood what Judge Gevers was saying, was the child either can read or they can't read. And if these children, whether they're Hernando County kids or the other kids, if they can read, they ought to be promoted. If they can't read, they shouldn't be. And whether they took a test which scored a particular level or not is not necessarily the same as whether they can read or not.
She does, but the question becomes, how do you get there? How do you get there for the whole school system for the state of Florida? Because what the plaintiffs in this case want, except for one Hernando student, the first named party here in our case, Teresa Butler, her child took the FSA, scored a 1. The child took the SAT, failed it, went to the reading camp, did everything under the statute, and in October of this year, after the hearings, was promoted into 4th grade. And in fact, if you look at 10028 25-7, it says that you go into 4th grade except for reading, and that's exactly what happened. So one of them very successfully went through and is in 4th grade with a mid-year promotion. But is it the parent who's supposed to say that my kid can read, because that's what these parents are saying, or they're saying that these report cards, which go from A to D, are sufficient for the purposes of reading? Well, it's not sufficient for the purpose of the legislature. It's not sufficient for the purposes of the State Board of Education. And according to what we are told as school districts, it's not sufficient for us either.
Well, let me ask you this, and it goes to the authority question. If in Hernando County, the school board consists of people who don't like these standardized tests, and so they take a very liberal view of the statute and say, if they show up, they Christmas tree it, good enough for us, we're going to just jump immediately to the portfolio option, look at their report card, and we're going to pass them through. Social promotion at its worst. If the department, and so that, in that hypothetical world, the department has a rule, though, that says to participate in a test, you actually have to make a good faith effort to pass it. You then, how would that play out? Do they have the authority to dictate to you how to evaluate under this statute, or no?
We get our funding from the state and the federal government based on this test. That's how the money comes through. And I haven't seen that scenario. I don't know that scenario, but my best guess is in answering the question as honestly as I can, they'd probably cut off our funding if the school board said, the school board of Hernando County is not going to pay any attention to the FSA. Everybody should fill out, I think when Judge Wolf said, just do C all the way down, okay? Because the purpose of the test is to determine if there's a reading deficiency. It's not for the, it's an assessment that people feel is reliable, and it's not the only determiner, but it is one. And it's certainly the point of entry into the issue of, do you get a portfolio, do you get an assessment? And again, to underscore what was said before, every one of these children was offered an assessment, every one. Some of them were offered a portfolio in Hernando County, but it wasn't necessary, because the one child who had veiled themselves, took the test, took the SAT, went to the reading camp, did everything that was asked of them. All of the people who testified for the plaintiffs said was, we don't want our child to answer a multiple choice question under any circumstances. And the portfolio option, which they refused to accept, has multiple choice questions by rule. And they said, we will not accept the portfolio option. All of them will not accept the portfolio option because it has multiple test questions.
What prong does that go under? I mean,
prong of the temporary injunction?
What I hear from you there is the absurdity of their position, the inequity of their position. I mean, what prong in the injunction statute?
There's no harm. There's no harm to these children. The only harm, and the judge said the school districts and the parents harmed these kids. The parents each testified, I told my kid to go through the door and not answer that test. Sign their name on it, break the seal, and done. And now the children come crying into the court. One of them came in and actually cried on the April 12th hearing, or the August 12th hearing, because said, I can't go to fourth grade. Well, of course, they could have gone to fourth grade for everything but reading, but didn't. But the point is, that's not the harm. And that's the problem with that, is that there is no harm demonstrated. There's no harm in taking a multiple choice exam. What, are they never going to take a driver's license test? I just don't understand that concept. But it is their position that they should not have to do it. On the home rule issue, there are only 4 exceptions to that home rule issue. Only 4. And this court has dealt with them in Levy County versus Bowdoin. It's dealt with it in which the Supreme Court case in Sun Sentinel said, we are looking and reaffirming what the First District Court of Appeals said in JEA versus Clay County.
And I don't think there's any argument here that any of the recognized exceptions apply. Correct. I think the argument and what the trial court found was that the home venue privilege was waived, which is separate from the exceptions. You would agree, right?
It is. And what they were saying is that we exercised our right and obligation under 28 U.S.C. 1446A to go up and remove the case to federal court because the first complaint was replete with federal causes of action. We were obligated.
And I think to the extent that was all it was, there would be, I mean, that's clearly, I mean, almost borderline frivolous to suggest that exercising a right of removal in and of itself constitutes a waiver of home venue privilege when you can only remove it to one place.
And that's their argument, by the way, in the case.
But in this case, the trial court relied upon more the representations made to Judge Walker, which were, we want to be here, Judge. Why is that not?
I am the only one that said that sentence, and I said it, and maybe I misspoke, but if you read the sentence before that, and I have it right here, if you read the sentence before my quote in front of Judge Walker, which is Appendix 4, I believe, no, it's Appendix 15, page 37. What I said precisely before that sentence is this. I'm done. Certainly, if it's remanded back, we are going to request that a state agency with home privilege that we be entitled to have the case heard in our home venue, and that would be in Hernando County. Every single lawyer for the school boards said that, and they also said we want to transfer the case to the district or division where we are located. And that's a fact. And there's no waiver there. And the Florida Now case does not speak to that at all. Does that answer your question?
Answers my question.
Thank you. Your rebuttal time.
Yeah, thank you.
Good morning. Andrea Mogensen on behalf of Appalese. I would first like to address the venue question that we just ended with. It's a little bit more discreet and a little easier to handle shortly, and I don't want to forget it. I do think that the trial court findings actually were two things, that the waiver that was suggested by the court, but the trial court also found that Leon County was a proper venue because that is where the Department of Education is located. That is where their home venue privilege would dictate that this case be held, and she further found that the Department of Education was an indispensable party.
How are they indispensable?
Well, I think that became clear as the evidence came out, really why they're indispensable. They're indispensable insofar as they have a statutory responsibility for supervision of each of the school boards. And when the evidence came out as to why the school boards acted the way they did, generically speaking, the answer was we were directed by the state that this is the way to apply these statutes, this is the way to apply them.
How did your client, why are they indispensable for your client? I can see them being indispensable for them to argue what we just followed what the state said. But couldn't you have gotten the relief in Hernando County that you got in Leon County? I mean, if they want to bring the school board in, the state in, that's fine. But either their behavior in Hernando County complied with the statute or not. So why couldn't you get relief in Hernando County under declaratory judgment action under Chapter 86?
I would expect that we would have endured a motion to dismiss for failure to join an indispensable party because it's the Department of Education who has the supervisory responsibility and ultimately the responsibility. The Department of Education is the one who assigns whether or not a child has participated. It's the one that gives the code as it came out in the evidence, the NR2 code, and that's what actually dictates what category these children fall into. So they're an indispensable party from that point of view, and that's why Judge Gevers found that to be true.
You know, I have to go back and look, but I think I wrote Jacksonville versus Clay County. And I said that there are four, I think I said there were three, and then the Supreme Court added a fourth, exceptions to the home venue privilege. Mm-hmm. One of them is not an indispensable party. Aren't you asking us to change the law on home venue privilege by creating this indispensable party exception?
I don't think we are. Under Grice, the holding in Grice was that the purpose of having home venue.
The key thing there in Grice wasn't it joint tortfeasors in that case?
It was, but with the Grice.
Exception related to joint tortfeasor.
But with the Grice
court. It's not a tort claim, is it?
Agreed. But what the Grice court actually said was that the purpose of the home venue privilege was for efficiency, and it was not appropriate to apply the home venue privilege where it would result in severance of suits, in disparate results across the state, and they used the word further. Further, we're going to specifically hold that this won't apply for joint tortfeasors, and the same rationale applies.
And if the Florida Supreme Court wants to adopt a fifth exception, it's free to do so. The trial court had no authority to do that, did she?
I think she did, because subsequent to Grice and subsequent to JEC, Sun Sentinel came through, and the trial court there went through the same type of analysis that Judge Gevers did with regard to Chapter 119 cases, public records cases, and looked at it and said, look, when they're public records and they're in the jurisdiction where the suit is brought, it's not rational, the purpose of home venue is not served, this should be another exception, and that trial court took that step, and they were not reversed by the Florida Supreme Court, because that's the only way that the Florida Supreme Court will ever take a look. And in Jackson Electric, they actually tried to certify the question. The Supreme Court didn't look at it. The only way it's going to get
Let me ask you this. Assuming we accept your premise that the Board of Education was an indispensable party because it's the one who says to participate means you actually have to participate and try, why isn't your remedy for challenging that department policy, the Administrative Procedures Act, thereby giving you a alternate remedy at law rather than this circuit court action?
Well, what the argument is not that the rule is wrong, but the argument is, and what the objection that the plaintiffs brought to the circuit court was, is that the state statutes are not being applied. And it's,
well, that has nothing to do with the Department of Education.
It does, insofar as the
Department of Education is not applying these statutes to determine that these children do or do not go to fourth grade. It's the school districts. I mean, as I understood your argument, we had to sue the Department of Education because they're the ones that adopt this policy that's being implemented by the school districts. I misunderstand that argument?
No. Under the statutes, Florida Statute 1001.03, the Department of Education is responsible for enforcement of the laws as to the school boards. And they admit in their brief that they have administrative responsibility for the FSA. And their own expert testified, Juan Copa, at tab H of 1377 and 78, 1400 to 1402, that the department, by some type of administrative fiat, without a rule, without a publication, without something that can actually be challenged, designated in their leadership that when a child sits down, signs their name, breaks the seal, and answers one question, that they're designated as participating in this examination.
Well, the place where you challenge administrative fiats that aren't adopted as rule is not the circuit court. It's the Division of Administrative Hearings. So why, again, isn't that, as to the department, a sufficient alternative remedy at law that should have precluded the entry of an injunction? I mean, because the injunction you got against the department was, in effect, by administrative fiat, by judicial fiat, tell the school districts it's okay to let people opt out of the test, wasn't it? I mean, that's the bottom line, isn't it?
Well, the term opt-out is used for a movement, but in the particular facts of this case, these aren't kids that didn't show up, didn't go to the test, and the court found that they actually did participate because they appeared and signed the test and filled out.
That's ridiculous. I mean, that's ridiculous, isn't it?
It's equally ridiculous for the school board to ascertain that one question counts as participation, and if we were really here.
But none of the students here answered one question, so we don't have to address the ridiculousness of that. I mean, the idea. Well, help me understand this.
Excuse me, I'm going to interrupt. Okay. It's a little unusual, but we're going to take a 5-minute break and we'll come back to your question. I apologize.
Okay, very good.
All rise. Carry on. All rise.
Okay, take your time coming in. Don't worry about it.
First District Court remains in session.
Be seated. Take your time. Okay, whenever you're ready.
I actually do think that we do need to get to the ridiculousness of that position, because that's the position that the government needs a rational basis for taking. And that's the crux of the equal protection argument and the substantive due process argument, is that they can't unreasonably interfere with these students' access to the statutory opportunity to apply for a portfolio. And the rational basis that they've put forth, they've never given a rationale for. What is the rationale that one question would put these kids in an entirely different category where a portfolio would be available to them, whereas zero didn't?
I guess
that's
my
the purpose of the APA, though, to go through and let them ferret out their policy and which way they want to go on a rule, rather than on an ad hoc basis by a circuit judge.
If there actually were a rule, that would be helpful. But until you go to circuit court on a junction, that's where you actually learn that one question's the difference. It's not published
anywhere. There's a procedure
anywhere.
under the APA to challenge non-rule policy, and you're saying they have a policy. So that could be challenged under the APA, and that gives them an opportunity to ferret it out. I mean, that's my concern. I'm not saying the policy is good or bad, but if you're challenging their policy, that is normally done through the Administrative Procedures Act. And I'm not sure why I see the necessity for the circuit judge to be jumping into that. Because all she told, as I understand the relief granted against the department, is you tell these people this, you tell these people this, you tell these people this. To me, that's saying, department, you shall adopt a policy. Or this shall be your policy. What business does the circuit court have to do that?
Well, I think this court addressed that in Amerisure Mutual versus the Florida Department of Financial Services, that agencies are afforded wide discretion in their interpretations of the statutes, but that the courts are not, it's not required that there be judicial adherence when the interpretation is contrary to the plain language of the Florida statute.
That wasn't a circuit court injunction case, was it? Wasn't that an appeal from an administrative final order?
It was, but in this circumstance...
That sentence you read is just the general principle that judicial deference is given to agency interpretations unless they're clearly erroneous in the context of an administrative proceeding. I mean, here, it doesn't look like she gave a whole heck of a lot of deference at all to it. I guess my question is more fundamental. Why should the courts entertain and provide relief, much less emergency relief, in this type of a circumstance? I mean, I just can't fathom a parent going and telling little Johnny on their way to school, I don't want you to try today. That's ridiculous. Why should the courts provide relief? Why isn't their argument of either a lack of harm, this is self-inflicted harm, versus the equitable clean hands doctrine, why wasn't that in and of itself enough for this trial court to be reversed?
Because the issue isn't really whether Johnny tried today. The issue is that these parents attempted to access the portfolio exemption under the...
No, what the issue was, the parents didn't like the rules established by the legislature of the state of Florida, so they took it upon their own hands at the detriment of their children to subtrovert what the legislature of the state of Florida has mandated. That's what happened, isn't it?
With all due respect, they relied on the Florida statute that commands that the Florida assessment test is not the sole determiner of promotion, and they relied on the Florida statutes that permitted them to make application for a portfolio option. It is the clear intent of the body of Florida statutes under discussion that there's more than...
What you're looking for is to allow them to go use this assessment mechanism or use the portfolio mechanism. And I'm still having trouble seeing why that can't be handled in the Circuit Court of Hernando County.
Because according to the School Board of Hernando County, the Florida Department of Education directed them otherwise, and that they're bound to follow the direction of the Department of Education.
You know, if I was a circuit judge in Hernando County, I'd say, I don't care what the department's telling you. The statute says this.
Well, I think that it goes back to the statutory schemata and the concession of the Department of Education that they are responsible for administering the FSAs.
Well, if they want to intervene, that's their business. They could go down to Hernando County and intervene. Then we're not worried about venue privilege.
Here again, as cited in our brief, if you fail to join an indispensable party whose rights will be affected, we're subject to dismissal.
But under your argument, it seems like the Department of Education or State Board of Education, whatever it is, would be an indispensable party on every pupil decision that's ever made because they have this broad overriding authority over the state education system.
That's not the position we're taking.
Well, isn't that the end result of the position you're taking?
No, because the statutes 1001.03 makes the department responsible for supervision and enforcement of the law, not necessarily of promotion. And this case isn't really about, we didn't move the circuit court to get these kids promoted.
Well, isn't that the fundamental problem with this case?
We moved the circuit court for the relief of access to the portion of the Florida statutes that both the department and the
to achieve what?
refused to recognize.
To achieve what? To achieve a promotion of the child, right?
To achieve access to that which the legislature intended them to have access to. It's the clear intent.
To accomplish what?
Well, ultimately, to accomplish promotion. None of the kids who made application in Hernando County, and counsel has represented otherwise in a footnote, but it's not in the record. The record shows that the Hernando County students, none of them had a reading deficiency. They all scored at or above grade level on their report card.
Then why didn't they take the test?
Because their parents relied upon that. The Florida statutes actually permit for more options.
Florida statutes mandate all students participate in the test.
They do. And the circuit court held that the students did participate in the test. The Florida statutes also prohibit retention based on there's no remedy that says non-participation results of retention. The mandatory retention statute was intended to prevent people with a reading deficiency from moving forward. And specifically, the Florida statutes.
So let me get this straight. The plaintiff's children, in your view, had no reading deficiencies. Yet they were unwilling to take the test to demonstrate they have no reading deficiencies. And as a result of that, they want a circuit judge in Leon County to mandate that they be promoted to fourth grade. How is that equitable? How is equity on your side here?
No, sir. The suit was not brought to mandate promotion. The School Board of Hernando County and the Department of Education took the position that they would not respect the Florida statute, would not honor the Florida statute that allows parents to make application for a portfolio. The statute that defines what the portfolio option is requires the teacher to assemble the materials. It specifies what materials are to be assembled, and they're to be done by the teacher and given to the principal. That's not something
the portfolio option was offered in other counties, was it not?
And that's the equal protection problem, is that if a child is seated in Orange County or Citrus County.
And the department didn't go down to Orange County and say, you can't offer the portfolio, did they?
Evidently, Orange County ignored the direction of the department. Hernando County did not. But it's the way the child comes through coded from the state when the test is taken, because these kids did sit for the test and they did get a response code, as compared to a child who never showed up, didn't appear, actually opted out and blew it off. They actually received a code from the state. And those codes were given neither notice of a reading deficiency nor notice of non-participation. They were given notice in the last few days of the school year that they weren't going to promote.
And then you waited for 3 months to file a lawsuit.
Well, here's the thing. Once those parents learned on the last 2 days of the school year, and these are parents across the state of Florida, they had to find counsel. The policies had to be reviewed. The affidavits had to be drawn, and a 100-page complaint had to be put together. That's actually...
Wasn't there evidence in the record that Hernando County did offer portfolio options to these students? The parents just found those unacceptable portfolio options.
I'm sorry, can you repeat that?
I thought there was evidence in the record that Hernando County did offer portfolio options to the two students who were the only ones for whom injunctive relief was awarded.
That was actually the rationale that the judge used to deny relief to the Orange County plaintiffs. That's
So
not
your representation to us is that Hernando County did not offer portfolio options to the 2 students who were awarded adjunctive relief. That's your representation.
Hernando County said that no student can have access to a portfolio option unless they have participated in the FSA to the extent that we designate participated by 1 question versus 0. And that's the issue, or the SAT 10. And it wasn't so much what the content of the portfolio option was, as they said that's not available. That's not available to any student who doesn't take these steps first. And while participations in the FSAs are mandatory, it does not say in the Florida statutes that failure, the remedy for not participating to the degree
Right.
that's
So
designated is not
I think you kind of fine-tuned your response there. So these students didn't participate in the main test, the FSA.
They did.
They didn't. I mean, they didn't participate. The trial court seemed to believe that they did. They didn't. Or let's assume for hypothetical purposes that the trial court was wrong by writing their name on it. That's not participation. Assume that. So they didn't do that. So Hernando County, as I understand it, and I think as you acknowledge, they said, okay, you don't want to take that test, take another test. And they refused to do that, correct?
Take another test, take another test, take another test. That's correct.
They 3 times they said take
Well, I don't
tests?
know.
I'm trying to get the facts. I mean,
They actually did it during the proceedings and during the hearing. But what's being ignored both by the Department of Education and Hernando County is that the Florida statutes clearly intend that a test not be the sole determinant of a promotion. It's not a conditioned precedent.
Who gets to choose? Who gets to choose which exception to the FSA? Do the parents or do the district, in your view of the statute?
In my view, the state legislature does. And they've provided for that option by application of the parents. And they have not mandated or dictated or directed that that option is only available after the FSA is taken. They put that option in there. They said that promotion.
All right, let me try this a different way. Let me try this a different way. Mr. Bush represented to us that the record reflects that these students who, I'll give you the benefit of the doubt, minimally participated in the FSA were offered an option to take an SAT 10 or whatever the number is test. They refused. They were offered to do the portfolio option as dictated by the rule of administrative procedure. They refused. You dispute that representation, correct?
Correct. The portfolio.
That's not what happened in your view. So either you're right or Mr. Bush is right about what the record reflects.
Hernando County has always taken the position, the clear position, that a portfolio as defined in the Florida statutes is not available until you sit for a standardized test passed from.
That's exactly what Mr. Bush said. So you're now agreeing with him that the reason your clients were not offered a portfolio is because they refused to undertake either of the conditions precedent, either the FSA or an alternative assessment, right?
Right.
Okay.
And that's an interpretation.
So why should the courts get involved? Why should they grant you emergency, or not, maybe not even emergency, but extraordinary equitable relief when you refuse to avail yourself of the options in the statute?
Well, that is precisely what the plaintiffs were trying to do, is avail themselves of the options in the statute. And the limitation of the authority of both the Department of Education and the school board is what the legislature allows them to do. And the legislature clearly intended that more than one method be used to determine promotion. And it clearly provided for parent application for a good cause exemption. And Hernando County and the Department of Education would not allow them to make that application without additional conditions that are not provided for by statute. And further, they punished them for their difference in opinion about it by retaining their children.
But I thought you said this lawsuit wasn't about whether they're promoted or not.
The Florida statutes do not allow the FSA to be the sole determiner of promotion, and the position that they have taken without a rational basis, with unreasonable government interference, is that if you answer one question, then a portfolio option is available to you. If you answer none, there are not. And that's something.
Did any of these students at issue, I guess there's only 2 that are relevant anymore, they answered 0 questions, right?
Correct.
Okay.
And then the reality is, you can't challenge that policy. It's not published. It's not written. It's not anywhere. It actually was learned in the hearing in circuit court that was the basis on which the department was designated.
And don't follow the APA every day. But unless the law changed, you have a right under the APA to establish that the department does have a policy that they are implementing, that they are not doing by rule. And then that policy gets stricken. That's done under the APA. It seems like your argument with the department is you have this policy, you haven't published, you didn't do it by rule, it's arbitrary, and if you want to challenge that policy, you say you should be able to do it in circuit court. And my response to you is, why should you be able to do it in circuit court and circumvent the APA process?
Well, what Judge Gievers found was that...
I understand what Judge Gievers found, but I want you to tell me why you should be able to circumvent the APA process.
I don't know that it's a circumvention of the APA process. The argument for injunctive relief was for the equal protection for students sitting in Hernando County are going to be treated differently than students sitting in Orange County. In Citrus County, evidently, the teachers start assembling the portfolio at the beginning of the year. In Hernando County, they will refuse to do so. This is a statutory opportunity that these children have and can make application to. That is the will of the Florida legislature. That's the avenues that were provided. Mandatory retention is only mandatory unless a good cause exemption applies. And if one district vis-a-vis the direction of the Department of Education or portions of one district prevent parents from making that application, prevent students from availing themselves of that.
The policy of one district prevent it. So again, it goes back to why isn't this just not a suit between you and Hernando County? Because obviously the department's not implementing this policy in other counties because other counties offered the portfolio option against the department's wishes.
Well, for purposes of this appeal, it is with regard to Hernando County, and it is with regard to the Department of Education and not other counties, because that was the ruling of the court that was the basis of this appeal.
Counsel, assuming for the sake of argument that we agree with you that you didn't have to exhaust your administrative remedies in this case, for those Hernando County appellees whose claims were not moot at the time the trial court entered the injunction in this case, what was the factual basis that supported a finding by the trial court of irreparable harm for granting injunctive relief in this case?
The factual basis for irreparable harm, each of the parents of each of the children, I shouldn't say each, for several of the children who were plaintiffs in this case, gave testimony with regard to the harm to their child. And the trial court specifically found that the failure of the school board and the department to follow the Florida statutes causes that harm, and that there was ongoing and continuous harm to the children who were not seated in the proper grade with a reading, the absence of a reading deficiency.
So the harm that you think the record reflects is based upon the fact that these children were not promoted to the grade they ought to be in?
Yes, and specifically that the way that the harm occurred was that there's a statutory opportunity to make application for a portfolio option which only includes certain items. The parents made application for that and were strung along till the end of the school year, at which point they were told their children would be retained, and specifically in Hernando County, the report card said for FSA scoring. When a family looks at what the statutes are, what the family looks at what, and these people did.
You're not suggesting, I certainly hope, that the parents suffered some irreparable harm here, are you?
Well, actually, the court did find that notice was required to the parents, so they have a responsibility, along with the fundamental right to the control of their child's education, but they have a responsibility to do that. And when they make application for a statutory exemption and are led to believe that that's going to happen, but only find out at the end of the school year that the children will non-promote for FSA scoring, when there's a statutory exemption.
It's the students either being in third grade or fourth grade. I mean, what evidence was there that the parents were harmed by their child being in third grade rather than fourth grade?
the evidence, as I suggested when the question was originally asked, is that there is parent testimony as to the harm to the children. The government, right, but the government put on evidence of what struggling students benefit from retention, but it was not addressed by the government what retention of reading proficient students is about, and that's what this case really is about. The evidence.
But again, I mean, I hope you don't think I'm being unfair with you, but I'm trying to get clear answers to my questions, and I think, I mean, initially you tell me, yes, the parents, harm to the parents was established, and then you talk and essentially get to the bottom line, which was it's harm to the children. I mean, the parents have nothing to do with this other than their selfish view as to what the state policy ought to be.
The trial court actually found both.
What then, tell me what then the trial court found as to the parents' harm.
The trial court found that these parents were not given the statutory notice of either deficiency or notice of non-participation. The government is under obligation to give notice to these parents one way or the other. They got zero notice. That for the last few days of the school year, they got notice of retention. They didn't get notice of a deficiency or notice of non-participation, both of which are required by the Florida statutes. And a parent who is governing their child's education needs that notice, that input, and it's statutorily required. And that's what the court found.
But the bottom line isn't that because the parents didn't get notice, because their kids didn't promoted, the parents went into a psych ward or something. I mean, the issue is because the parents didn't get notice, because the kids weren't promoted, you had kids that could read that sat in third grade and felt bad about it. That's the harm, right?
Well, not exactly. There was also testimony about the harm to students who are required to spend a year on materials over which they've demonstrated mastery.
But let me ask this, and this is a question ultimately to the agency as well. The statute, as I understand it, if you get a good cause exemption, you get you score. Let's assume you have a student that actually tries on the FSA, but they just do poorly. They score a 2. They don't get a passing grade. But they go in and apply for a good cause exemption and assume it's in Orange County where you want to be, and they give you a portfolio option. They look at the report card and say, Johnny's got good grades. The teacher thinks they can read, so they get promoted. As I understand the statute, under 6B, a student who's promoted with a good cause exemption shall be provided intensive reading instruction and intervention in 4th grade. So they move on to 4th grade. They're getting intensive reading instruction. Why wouldn't a student who in your view can read would be adversely affected by being held back in 3rd grade, is a proficient reader being held back in 3rd grade, why wouldn't they be equally irreparably harmed by getting a good cause exemption and being subjected to intensive reading instruction that, in your view, and in my hypothetical student, they don't need?
Well, part of the remedial efforts that are required on the part of the school boards when there is promotion with the good cause exemption also includes diagnostics. So presumably the intensive instruction would be tailored to the needs of that particular child as required by statute. So that's where I think...
And if the child has no needs, yet the school is required to give them this intensive education, I mean, that's where it doesn't make sense. I mean, that's where your theory that a student who has a reading proficiency that for their parents' reasons don't want them to take the test are entitled to a good cause exemption, but they're going to get this intensive reading instruction unnecessarily. That doesn't make any sense. So that would suggest to me that your theory doesn't make any sense.
Well, if the diagnostics are done properly as required by the statute, I don't know that that's the case. And I'm obviously picking up on the fact that the court doesn't necessarily agree with the approach that these parents had their children take to the FSAs. However, that's not actually the position of the state or Hernando County, because they clearly suggested that these kids would have been considered for good cause promotion if they answered 1 question versus 0. And I just want to refocus on that before I go. I know I'm going a little over, but that's what this is really about. Is not about necessarily what I think or someone else thinks about what these parents should have done. It's about how the government treated these students differently than other students without a rational basis, because it may actually be better in some people's view to say that participation is at least 75% or 90% of the test or best efforts or something else.
May I ask one question? Yes. Before you sit down, counsel, Does the record reflect how many of Appellee's children from Hernando County are currently enrolled in the Hernando County school system?
The record does not reflect that as of today because the record only contains what was true as far as that hearing. And because the hearing was held very immediately, and I know that counsel has suggested that that was unnecessary delay, but it's obviously a very complex and layered issue. There were multiple plaintiffs. They were unable to find counsel except for one. And I don't have a multiple attorney firm. It's just me. So the 60 days it took to put together, to put it right before the beginning of the school district, and that's what actually generated the emergency, was the state indicating in the last few days of the school year that there would be retention for this. The only information in the record is what was true with regard to the dates of those hearings. I know counsel has tried to proffer in footnotes updates about that. We actually have some disputes of fact about that, but I didn't address them because those are not matters that are part of the record.
Thank you, counsel.
Thank you.
Just a couple of points. And
Okay, I'm going to direct you since you have limited time.
yes, I see that. Okay.
I may not agree that the department was an indispensable party to the lawsuit. You know, I know you don't agree with that.
Right.
But let's assume for a second they were. I have a little concern here how we deal with this case where Hernando County obviously is an indispensable party. They have to be sued. And if the department was also an indispensable party, what does a plaintiff do if they want it resolved at one point, you know, in one location? You understand my question?
Yeah, I understand that. I may defer to Mr. Bush to answer that on the venue point, but I've got to correct something which is an embedded assumption that is just absolutely not in the record of this case. And it's been repeated again, and it goes to the point you've just asked, which is no one from the Department of Education directed Hernando County or any of these counties to promote, not promote, to offer or not offer the good cause exemption. That is not in the record. And so when we hear over and over again that the state directed these counties to do anything, not true. And I would invite the court to look at the record carefully on this point because it is not in there. At most, all that was said is that if a county believes that they should go through an FSA and an alternative assessment before going to the portfolio, then that was permissible under their local control prerogatives and under the Constitution. No one from the state directed anyone to not promote these children or to not offer the portfolio. That's the fact. And so saying it over and over again doesn't change that. So,
Counsel, let's assume for the sake of argument that we agree with Mr. Bush's arguments concerning the venue privilege. How does that affect the resolution of the issues against your client in this appeal?
well, the matter could be severed. I mean, the problem is this thing is so jumbled up, it doesn't make any sense. But it could be severed theoretically that the issues, whatever issues there might be against the state, would be dealt with in the Circuit Court of Leon County, and then the actual decisions, whatever it is they're challenging, would be dealt with in the county where the decision actually is made. Okay, well, that makes sense.
Well, it doesn't make sense. If you're raising the issue in both cases involving the same student, it makes sense where you can get two inconsistent rulings, one from Leon and one Hernando, involving the same students. I'm not sure I buy off on that one.
Well, but the problem is, again, the state board does not make decisions and did not make any decisions about any one of these individual children.
I understand that. But, you know, again, when I started the questioning with you, I said, let's assume you're an indispensable party. And
it's just hard to assume, given the constitutional structure that we have in the state of Florida, that the state would be an indispensable party for the decisions that are at issue here. It isn't. And that's the problem I'm struggling with in responding to that, because under no circumstances can I imagine that this decision would ever be directed by the state. It wasn't, and it would never.
You would move to dismiss because we're an improper party. But let's just say, assume the circuit judges, because I want to address this darn statute. I'm just having problems. You know, how does a plaintiff deal with where you really have an indispensable party that's a state agency?
Well,
I'm not sure this is the case. But
yeah, I don't think it is, so I will give Mr. Bush his minute or so to deal with that in terms of his issue. But I did want to clarify that, again, there's no decision or directive by the state here, and that's the record. And I also want to make it clear that there's no procedural due process claim. So all this talk about there wasn't a notice, there was a notice, or whatever, these parents knew what they were getting into when they did this. They knew what was going to happen. So it's absurd to suggest, well, we didn't know, and we can't possibly have imagined this could happen. That's ridiculous. And I would say, of course, they drop procedural due process. That's not in the case, so it's not a claim. The theory of harm is mismatched with the injunction that was offered. And I think Judge Wetherell...
I'm going to cut you off because I want Mr. Bush to
get
here.
Those are my points, so thank you.
I exceeded my time to Mr. Testani.
Well, I want
he wants to hear.
He keeps on saying that you're going to answer questions, so I want you up there to answer it.
To answer the first question that came out, most assuredly, on August 12th, the plaintiffs came in and said, we are seeking emergency relief to go to fourth grade. That's what that TRO hearing was about. And to say otherwise makes no sense, because they all said, we want the court in Leon County to order us to go to fourth grade. In answer to your question about the indispensable party, may I?
Yes.
Okay. The suit against the state, and again, we raised this in our motion and brief in front of Judge Gievers, was, look, Chapter 120 says what it says. The state should have been brought into DOA under Chapter 120 to say, we don't like the statute, we don't like that rule. Okay? That has nothing to do with us. We are implementing a rule based on how we understand it, the way we deal with our children. The state's not an indispensable party for us. And we wouldn't bring the state in because we know what the statute says and we know what the rule says. This is how we interpreted the rule. Okay? And so the state's not an indispensable party for us.
I understand that, but nobody wants to answer my question.
Oh, I'm sorry.
We got to write an opinion here. And you're arguing that the state's not an indispensable party. And I may agree with that. I'm saying one way or another. What I'm asking is, in the case, because I want to be careful when we come out with an opinion, we don't ruin the law forever.
Hard cases make bad law.
Where the state agency is an indispensable party, and you have a city government, a county government, a school board, that's also an indispensable party. And it's litigation over one child or one whatever. What's the remedy? What does the plaintiff do in that situation?
Well, first of all, only the Florida Supreme Court can say that, as you know, from the JEA case. Yeah. And you mentioned the JEA.
I think you're right, but I'm just...
Well, let me just say, Judge, you've been snake bit twice because you were also on the panel in Levy County School Board versus Bowdoin, which had the same result.
I've been on this court too long.
Well, but this is, I think, from my research, your third home rule venue case. And so only the Supreme Court can carve out a fifth exception that says indispensable party. In this instance, you're asking, is the state an indispensable party to me? And I say no. Are we indispensable parties for the state? Because if we are, all 67 counties need to be here. You can't say that only a few counties are affected here because there's 67 counties in the state of Florida.
It would seem to me that if this had gone where it should have gone, which is to DOA, and they said the department has this policy that says you actually have to participate, and we don't think to participate and get the benefits of these other options, and we think that is not what the statute says, and you haven't adopted this as a rule in the first instance, so it's a non-rule policy. If that's where it had gone, and there were school districts out there that agreed with them, their remedy would be to intervene and defend their interpretation of the statute.
Correct, but we're not indispensable to their petition under Chapter 120 to attack that statute or rule.
I think that's right.
Again, Counsel, before you sit down, regarding the procedural argument, the venue privilege, let's say, assume for the sake of argument, we agree with you regarding the venue privilege. As to the second issue on appeal, do we reach the second issue on appeal? The merit
on the TRO?
On the TRO? Merits of trial court granting the TRO, yes.
I don't think that the court in Leon County can tell us that we have to accept report cards to promote these children, because that's exactly what we were told. Portfolios or report cards to advance these children to fourth grade. That's for the school board to decide. That's not for a court in Leon County to decide. Does that address your question?
Do you understand me?
Oh, I'm sorry.
If venue was proper against you only in your home county, Hernando County.
Right.
And we ruled the trial court erred in declining your motion to transfer venue to Hernando County.
Right.
As to the merits of the second issue on appeal in this case, would we reach that issue at all?
No, because the court didn't demonstrate harm. There are 4 elements to a TRO, none of which were met here. There's no record evidence that there was harm, and the only harm was caused by these parents. That the children can't go to 4th grade? Sure they can. Under the rule, they go to 4th grade.
I guess Judge Lewis's point, as I understand it, is if we say the trial court should have sent this down to Hernando County, we wouldn't need to address whether the merits of her injunction against you was proper or not.
I apologize. That's correct. If there's
we
no
might
venue
need to address whether the merits of the injunction against the department was proper.
Correct. I apologize for misunderstanding, Judge Lewis. The point of entry into this case for us is venue. In the absence of venue, there is nothing.
Thank you.
Okay,
Thank you very much. Appreciate the extra time, Your Honors.
Court will, being no further case in front of the court will stand in recess.
All rise.